Yeah, I'll introduce you. And then we'll open it like the second half. And we've got some questions prepared earlier. There's a 30-year-old.
To everybody in the waiting room.
I don't think there was a waiting room.
Yeah.
Okay.
So they're all, you enabled the waiting room when you set up the meeting. So they were all waiting in the waiting room. So you'll have to monitor if anybody's sitting in the waiting room.
All right. Yeah, Professor Smolin still has them on there.
So they can click on participants. Depends if you not them.
Mm-hmm. Professor Smolin is having technical difficulties. Mr. Whitcomb, so Professor Smolin just responded. Okay, so we're ready to go.
Should be good.
I take off my mask. Okay. Thank y'all for joining us. Unfortunately, Chloe Cardwell, the president of American Constitution Society, wasn't able to make it to it today. She got stuck at work. So my name is Jaime Garcia, president of the Federalist Society, and we're happy that y'all were able to join us in person and over Zoom. And also thank you to our panelists, Professors Ross, Professor Denning, and Professor Smolin, who is joining us online. So just to start off, Professor Ross is the Albert P. Brewer Professor of Law and Ethics here at Cumberland. He's a graduate of Stanford University and Harvard Law School, and he served as a litigator in law firms in New York City from 1979 to 1988. He's as some of y'all know, if y'all are 2Ls and 3Ls, he's a specialist in constitutional law and constitutional history. Professor Denning is a professor, the Starnes Professor of Law, and he is a graduate of the University of the South and obtained his law degree from the University of Tennessee and received an LLM from Yale Law School. Professor Denning also writes in the area of constitutional law and has written extensively on the Commerce Clause and the Dormant Commerce Clause, which we learned about in constitutional law. And Professor Smolin is a graduate of the New College of the University of South Florida and obtained his law degree from the University of Cincinnati College of Law. So now we're going to have Professor Denning Professor Ross speak to us first, sorry.
Thank you. Well, good afternoon. I've been asked to speak about the history and interpretation of the Constitution. And that's a tall order for 2 or 3 minutes. So I think the main point to make is simply that the framers of the Constitution grappled with a number of issues that are as relevant and as current today as they were in Philadelphia in 1787. And it's relevant today as they were 200 years ago, 43 years ago today, when the framers of the Constitution sent the Constitution out to the states for ratification. The principal controversies at the convention, as most of you probably know, were the relationship of the federal government to the states, to what extent would the federal government have certain powers. And as you know, the basic principle of the Constitution is that the federal government only has such powers as the federal Constitution gives to it. So the basic powers flow from the people, and the powers that are not specifically given to the federal government are reserved to the states and to the people. But the question is just how extensive are the specific powers that are given to the federal government? Particularly the commerce power and the taxing power give the federal government so much power as interpreted by the Supreme Court and by the President and Congress down through the years that the federal government has come to have much more extensive powers than the framers probably would have foreseen. That's not necessarily unconstitutional, but again, it does represent perhaps a change in the way that the Constitution was originally conceived. The extent to which the federal courts would play an important role is significant. The framers probably foresaw judicial review, but they might not have foreseen how important judicial review would become in our constitutional system. And then presidential powers, the framers were very concerned that the president might turn into a kind of tyrant. That's one of the reasons why they provided for the balance of powers, separation of powers between the 3 branches of government and the interrelation of those 3 branches. The extent to which the president, the courts, and the Congress have powers, and the way in which they interrelate was a matter of great debate at the Constitutional Convention and remain a source of controversy today. So many of the issues the framers grappled with in that long, hot summer in Philadelphia so long ago are as current as today's headlines, as you all know. Maybe Professor Denning can talk a little bit about methods of constitutional interpretation. I'm not trying to put words in your mouth, Fran. I shouldn't have said that. I mean, but would you like to talk about constitutional interpretation? Or?
I'll talk about anything.
Okay, great. Yeah, no, well, that's, I'm turning it over to you then.
Okay. Well, thank you all very much, and good afternoon or good morning. A couple of things that Bill mentioned, and then I can talk about constitutional interpretation. One thing that it's important to remember about the framers, they were very practical people. And they designed a government that did not depend on the virtue of the people that were in office. In fact, they sort of assumed that at some point, you know, you would have rogues and knaves in office. And so they designed the system to minimize the impact that such folks could have, you know, in terms of pulling the levers of power. And I think that's important to remember when maybe you dislike the outcome of a particular election. One other thing I would mention about the framers and about the framing, they really hit on a unique way of solving difficult problems that cropped up during the convention. So there were about 55 delegates to the Philadelphia Convention of 1787. And while they usually met in plenary session, whenever a particularly difficult matter came up, they would they hit on the idea of designating a committee to go away and address the problem and report back. And with, I think, almost no exception, any big problem that cropped up that sort of threatened the convention and threatened to, you know, have everybody just throw up their hands and go home, they had this idea that you just delegate to a committee, let the committee report back. And with that separation, and I think with kind of the committee working off on its own and everybody else talking about something else, that was a really interesting and successful method of solving these difficult problems. So constitutional interpretation. As Bill mentioned, the framers probably intended judicial review in some form. I think that they thought that that went along with the judicial power that was vested in the courts by Article 3. As Bill mentioned, they probably had no idea of what precise form it would take. Probably there was disagreement among the framers about what form it should take. But almost from the beginning, as the court began to, and the Supreme Court began to assume the role of, you know, expositor of constitutional meaning, you began to get these debates about, you know, how should the Constitution be interpreted? What sorts of criteria ought to be used to flesh out its meaning? And I think that these debates sort of were, they didn't really become a chief academic concern until probably the mid-20th century. When Brown versus Board of Education was decided, constitutional law became much more self-consciously theoretical, and there has been a lot more ink spilled over the last, you know, 70 years about what, you know, what constitutes legitimate interpretive techniques. And specifically, I think of the last 40 years, the debate has sort of resolved itself around to what extent should judges seek only the original public understanding of what the Constitution or its amendments meant when they were either adopted or ratified. And it's really, I teach a seminar in constitutional theory, and I think for some students, the material that we read that was published from about 1950 to the early 1980s is a little unsettling, because at that point, originalism had not come to dominate the theoretical debate in the sense that it has after that date. And there are a couple of reasons for this. I think chief among them is that originalism was sort of adopted by opponents of integrated or segregationists right after Brown, because their chief broadside against the decision was that the framers of the 14th Amendment never intended for that amendment to require integrated schools or integrated anything, really. And so for a number of years, originalism was in very bad odor because of its association with opponents of Brown and proponents of segregation. That changed when a couple of books were published by a man named Raoul Berger, who was a legal historian. And then when in 1986, when Antonin Scalia was appointed to the Supreme Court and began to champion both originalism and its statutory cousin, textualism. And I think then originalism gained much more sort of respectability in the academy, and people began to write about it and write against it. And that's kind of the debate that we've ended up with today. And I think it'll be interesting to see what direction the current Supreme Court goes in. I think Justice Gorsuch and Justice Kavanaugh have some very interesting and differing approaches to some of these questions. And I think that, you know, there is a possibility that we'll see an appointment or two over the next couple of years to the Supreme Court. And this new court, you know, has shown itself to go in some interesting directions. And I think that we'll sort of have to see what this sort of new Roberts Court looks like. And maybe Professor Smolin has a couple of thoughts on that as well.
Should I start?
I'm going to pin your screen.
Can you hear me?
Yes, we can hear you. And you're on the screen.
Okay, well, it's a little bit hard to talk to the American flag, which is what I see, which is great, but I can't see y'all. So I'm going to nonetheless try to do this. It's an honor to be here in the metaphorical sense, to be talking to you at least. This subject of the American Constitution is a part of what I would call America's identity crisis that we seem to be going through right now. I think there's a real struggle in which Americans define what America is in rather different ways, and unfortunately demonize those who see the country in a somewhat different way. The Constitution, because it's a very old document, is caught up in this debate. One of the main difficulties we have as we talk about the Constitution is the fact that we have such an old Constitution. This is the, as I understand it, oldest written governing constitution of a nation in the world. And it bears what I would call the scars of the past. And by that I mean, what I want to talk about here a bit is the amendment process and especially slavery. Because I think in this identity crisis Americans are, you know, having right now, one of the questions they're asking themselves is, how do we relate to the past? And when they ask, how do we relate to the past? Can you hear me, see me? Is things okay?
Yes, Professor Smolin, we can hear you. Everything's fine.
Okay, sorry. I just saw Jeff up there and thought there might be a problem. Thank you.
No.
So basically, when we relate to the past, some see in the past primarily the bad things, which were extremely bad: slavery, white supremacy, sexism. You know, if you look at this Constitution as originally constructed, it's very easy to see it as a document created by a group of white men, many of whom were slave owners, who essentially were not creating anything close to the kind of democracy that we have today. And the question then becomes, why should we be bound by this very old document from the past? So that's sort of the negative view of the US Constitution. I have a more positive viewpoint of it, which is to say, first of all, that it's a blessing or a good thing that we have such an old document because it keeps us humble. And we have this appendix way of changing it. There is this amendment process. Of course, we don't have very many of those for as many years as it's been. But the interesting thing about our amendment process is we leave the old stuff in there and we put the amendment in at the end, amendment 1, 2, 3, 4, 5, 6, etc. And so in that way, this document becomes like a glimpse into the past. We don't remove the bad things in the document. when we amend them. We show the changes, and we show when we made them. We show when we abolished slavery, when we granted free and equal citizenship under the law to all persons. We see when women got the right to vote. It's all there, step by step by step. And so I think it's very important to see this Constitution that we have as very much of a process. And I say that not to speak at first to what Brandon was speaking to, which is this question of evolving interpretation, but just looking at the document as a document. The document has evolved. If it had not evolved, we couldn't live with it. We couldn't live with the original Constitution without the amendments, which of course accepted slavery, did not grant women the right to vote, did not grant really anyone the right to vote in particular, in a way that would extend beyond white males. So the document has evolved, and we can see that evolution. And I think in one way we need to be a little kinder to ourselves. We should not presume that Americans were the only people in the world in 1776 or 1787 when the Constitution was created who were living with the kinds of bad things from the past. In fact, I don't have time to go over it all, but slavery unfortunately has a very long, ugly history, and it was still a commonplace throughout many different cultures of the world. We could have done better. We should have done better. That's another topic. But same thing with granting the right to vote to women as well as men. Again, most modern constitutions don't have to worry about that because they're created in the modern world. Ours shows us when these changes took place. But these changes that took place in our society were also taking place in other societies as well. If other societies had such an old constitution, they would have these marks from the past as well. So what this Constitution does is really create a process. And I really want to frame quickly this debate over how we interpret this Constitution around the issue of how much power the Supreme Court has, and whether or not you want the Supreme Court to have more power or less power, or at least to feel itself to be constrained. I think that the originalism evolving Constitution debate is about essentially, do you want to send a message to the justices that it is their job to evolve this document, their job to keep it in tune and up to the times, that they should be doing that according to their view of justice, equality, and rights? Do you want to send that message to them that they are free to recreate this document at will as long as they have 5 of 9 votes? Because however we dress it up, that's basically the message of evolving constitutionalism. Originalism acknowledges the great power of the Supreme Court, but tries to at least send a message to the justices that it is essentially the job of the people of the United States under the Constitution to keep our laws up to date. And if you just think about it institutionally for a moment, who is better situated to keep our laws in tune with the will of the people today? 9 people who went to law school 30 or 40 years ago, who, whether or not they're representative by gender or race, are wholly unrepresentative of the American people by other criteria. Basically, all of them went to one of 3 or 4 law schools. They come from a very legal elite background. They're, on the older side. Would you trust 9 people, 50 to 90, to keep things up to date? Or would you pick what the Constitution does, which is to have constant elections where the people choose new representatives depending on what they're choosing every 2 years, every 6 years, every 4 years? And so the primary mechanism that the Constitution actually has to keep our country current with its current needs is Republican representative government, not the justices evolving the meanings. The other thing that I asked my class to reflect on is, if you look at American history, to what degree have the Supreme Court been the good guys? To what degree have they been the bad guys on these basic questions that we now agree on? So if you pick out the questions like slavery, segregation, white supremacy, voting rights, whatever it may be, who was doing more good, who was doing more harm? Let's say the Congress of the US versus the Supreme Court. And I'm going to go through that very quickly. Please let me know when I need to stop. But again, slavery is unfortunately acknowledged in euphemistic language in the original Constitution in several places, but it's in euphemistic language. It's not interwoven. There's not a sort of a right for slavery to go on. In fact, it looks like it was designed to allow slavery to die out, is what I would say. But slavery did not die out. And so when the Supreme Court decided the Dred Scott case in 1850, the Supreme Court was the one who declared this Constitution to be essentially a pro-slavery white supremacist document. I don't have time to go over all the facts and nuances of the Dred Scott case and its treatment of the issue of a individual and whether or not this once freed slave was a citizen of the US. It's a long, complex issue, but the way that Chief Justice Taney wrote it up and gathered a total of 7 votes, as I recall, really put a stamp on the idea that this Constitution is explicitly pro-slavery, that this Constitution protects property rights of masters over slaves rather than protecting the person rights of the freed slave or the slave for that matter as a person or as a human being. And it did so in explicitly white supremacist ways. So in that battle, it's really the Supreme Court that is the bad guy in Dred Scott. Very few people would argue with that. Then we get the Congress going to work. It's the Congress that gives us the 13th Amendment, of course, working with the states, but it's the Congress that gives us the 13th Amendment, abolishing slavery, the 14th Amendment, providing for equal citizenship under the law and other rights, and the 15th Amendment that provides for the right to vote. These are the Civil War or Reconstruction era amendments to the Constitution. Congress gives us those. But then the Supreme Court, in response, undermines what was given. So it's the Supreme Court that in 1896 interprets the Equal Protection Clause of the 14th Amendment to accept white supremacist segregation as compatible with equal protection of the laws, a precedent that would last 58 years. It's the Supreme Court that in the 1880s, in the civil rights cases, would rule unconstitutional the 1875 Act of Congress, which tried to give us basically civil rights protections in public accommodations like restaurants, theaters, and so forth, the kind of thing that we would have to redo in the 1960s by the new civil rights legislation, because again, the Supreme Court struck it down. So Congress is the good guy in creating these amendments. The Supreme Court limits them. Okay, in fact, as we move forward, of course, we've got other horrific interpretations of the Equal Protection Clause. We've got the Korematsu decision that allowed Japanese Americans, including citizens, to be massively interned during World War II, man, woman, and child, without a scintilla of evidence of guilt. I could go on, but what I want to really stress is that we have what I would call the hero story of the Supreme Court, where, you know, this document's okay, but it's the Supreme Court that really saves us. And if you go back before Brown v. Board of Education, you can see that there's a lot of evidence that in fact the popularly elected branches were doing much better, and the Supreme Court was undermining them as to rights and equality protections. And as to the necessary evolution we needed to have, it was Congress that was giving it, it was the Supreme Court that was undermining it. Although I don't think it's in the same league, and I don't think it's an evil decision in the same way, you could look to the Shelby County, Alabama decision from the more recent Supreme Court, where it's the Supreme Court that undermined the Voting Rights Acts of the 1960s. Again, that's a more subtle case. They didn't invalidate the whole Voting Rights Act. I'm not putting the Shelby County, Alabama case in the same league as Dred Scott or else Plessy v. Ferguson, but it again represents the idea that often Congress has wanted to give more rights and equality protection than the Supreme Court. Another example that goes to religious liberty. Okay, it is the Supreme Court that in the Smith case around 1990 totally undermined religious liberty, taking away basically half of the rights. And it's Congress that tried to restore religious liberty with the Religious Freedom Restoration Act. And it's the Supreme Court that in the City of Bern case invalidated this attempt to give us a fuller vision of religious liberty. So what I really want to leave you with is this notion of evolving constitutionalism is based on the idea that you want to give the justices more power, but you don't necessarily want to do that. Really, if our country is going to come to grips with the past in an honest way and evolve into what it needs to be, the best tool of that, I would suggest, is not evolving constitutionalism from the justices, but it is, in fact, the democratic Republican governance process that the Constitution creates. I'll end with this quote from Holmes' dissent, Lochner v. New York, 1905. Holmes said, the Constitution, or rather a Constitution, is meant for people of fundamentally different views. In other words, the Constitution creates a way to politically and peaceably settle fundamental differences primarily through the democratic process rather than primarily through the Supreme Court picking sides. Okay, I'm going to end there. So we have plenty of time for questions. I'll move and see what we ask.
Yes, Professor Ross. These questions haven't been directed at any professor in particular. They're whoever wants to take it. So the first question we have was from a first year. Has the United States Supreme Court generally favored a strict interpretation of the Constitution or a liberal interpretation? And again, professors that are present would have to stand up to the mic. Sorry.
Okay, I'll field that one. I think it depends on what you mean by strict versus liberal, first of all. And, you know, the second thing is that the court is a they, not an it, right? Which is to say that there are 9 people on the court, all of whom have different approaches to interpretive methodology. So it's really, it's difficult to answer that question. I would say that at some points in its history, the court has tended to, members of the court have tended to, you know, adopt interpretive methods that are less concerned with originalism. And at some points, I think probably since the mid 1980s, I think that the tendency of the court now is to be a little more concerned with history, with precedent, and less inclined, with some exceptions, to adopt really capacious definitions. And even when the results are a sharp break from the past, I'm thinking about maybe like a Obergefell, the same-sex marriage case, the court was very careful to couch it in terms of, you know, making it look like it's not as sharp a break from the past as it perhaps was, because the court had previously recognized that marriage was a fundamental right. And so they said, oh, marriage is a fundamental right, so why should we deny it to same-sex couples? And which is certainly you know, a defensible approach, but it does sort of tend to cloak a sharp break from the past with, you know, couching it into terms that makes it look less so. So I think the current court's position is, even if it's going to make a sharp break with the past, to try to cloak it or make it seem less like a divergence than it might otherwise be. And I think past courts have been more candid about saying, look, we're going in a different direction.
Thank you, Professor Denning. So we had another first year that asked a question along with the quote. I don't know if you want to read that one. Okay, so the quote was, but whether the Constitution really be one thing or another, that this much is certain, that it has either authorized such a government as we've had, or has been powerless to prevent it. In either case, it is unfit to exist. And that is by Lysander Spooner. In light of the quote by Lysander Spooner, how do you see the Constitution actively curtailing the role of government in our lives as individuals? And I don't know if Professor Smolin or any of the professors here would like to take that question. We can't hear you, Professor Smolin.
Okay. That's a rather negative quote. Can I ask the student to comment on its origins?
It is from, I believe, a book by the name of No Treason, the Constitution of No Authority.
Okay. I'm not, basically, I think that the Constitution has been more effective than people think in the sense that it has created a way to hold us together as one country, despite the fact that we really disagree about the most important things of life. And in that context, it has been a vehicle to constrain power and to divide power. In fact, you could argue that the very structure divides power so effectively that it's difficult to get anything productive done in the sense of solving real world problems. And I'll give a simple comparison. In most countries, the executive branch is formed out of the legislative branch. And so there's always a concurrence between the cabinet and the prime minister or whoever the head of the executive branch is, and a majority in the legislature. That's the typical Republican Democratic setup, parliamentary government. And it allows you to have a better chance of getting things done in a sense because you've got a governing majority consistent across the executive and all of the legislative branch. On the other hand, with our direct presidential elections and our separate House and Senate, we usually have divided government. And we have therefore a lot more mechanisms to block legislation than to actually pass it. And we do have this very, very vigorous judicial review, which is exercised not only by the Supreme Court, but by the lower courts as well. So it's true that if you wanted a tiny government the way the government was before the New Deal or something like that, that it's not been effective. But I think it has been effective to divide and cripple power.
Thank you, Professor Smolin. So as you mentioned, elections. So this being an election year, one of our questions, of course, slanted a little political. And that question was, has the current president violated the Constitution in any way? And this, again, is whoever wants to take this political question. And I think we can generalize that. Has any, is it a common trend for presidents to, subvert the Constitution in some way? Just to make it a little bit level playing field.
I mean, I can take that if it's helpful, unless Brandon or one of the others coming up, they can go first because I took the last one.
Please, David, if you want to answer it, go ahead.
Okay. Were you able to hear
that? Sure. Okay. Well, I will say this. I think the biggest question with President Trump, and I will be transparent, and I've sent a bio to my own students so they know this. I did not vote for President Trump. I did not vote for his opponents as well, and do not intend to vote for either party. So I'm a bit of a political orphan right now, okay? So take it in that context. But as a political orphan who feels unrepresented by either of the two parties right now, I can say that a big question has been whether or not our Constitution is strong enough to handle the kind of president that President Trump is. And by that, I mean to say that from my point of view, while he's constitutionally fit to be president, his character and self-control lack the consistency, self-control you would want with somebody who has that much power. And so there's a question of whether the presidency is sort of strong enough or the US Constitution is. And I also am of the opinion that so far it has been. That in fact, the greatest distortion we've had is the overreaction to President Trump. And when I mean the overreaction, the tendency I'm trying to think of the right way to say this. As someone totally opposed to President Trump, I don't view him as somebody who has committed an impeachable offense, if I go to that direction of the question. I think that the Russia investigation was irresponsible and was not productive for the country, further divided the country without producing any evidence of an impeachable offense. I think the Ukrainian-oriented wrongdoing, while it was not a pretty picture, was not did not rise to the level of what we want an impeachable offense to be, because impeachment overrules an election. And it had bet, and that's why you need a supermajority to get there. So I think that basically there's been, unfortunately, some tendency to try to avoid democracy and avoid understanding why President Trump won the first time. He didn't cheat. It wasn't Russia. It wasn't this. It wasn't that. President Trump, with the electoral college system, which is controversial, which we could talk about as well, was properly elected president. And if there's many reasons to oppose him politically, and I do personally, but the attempt to avoid his election victory and avoid understanding why it happened has been crippling to those who oppose him, in my view. Is that clear? So he shouldn't have been removed constitutionally. If he's not going to be president, he needs to be voted out. That's how the Constitution works. Bill, you're welcome to jump into that if you want to.
Okay, next question. All right. So another question is, would it be fair to conclude that Article 1 is essentially dead? I don't know whoever wants to take that.
I mean, I guess, so the question is, in what sense? I take it the person asking the question is asking whether the system of enumerated powers is dead because the court has tended to broadly interpret the taxing and spending power in the Commerce Clause. I mean, so at the risk of putting words in the person's mouth who asked the question, I'll sort of frame it like that. And I would say, no. The court has shown a willingness in recent years to not only place limits on the power of Congress, but to police them as well. And I think the Affordable Care Act case, NFIB versus Sibelius, is a good example. So the court said it held two things. And the second one was less reported on, but may potentially be more important. Excuse me. First, it said you can't regulate inactivity. So Congress cannot force people who are not already participating in a market to participate. That's important because had it gone the other way, there are any number of problems that Congress could attempt to solve by forcing people to do something. And the second important part of that opinion, as part of the Affordable Care Act, states were incentivized to expand the Medicaid program. Medicaid, as you might know, is the sort of government health insurance for low income and disabled people. Congress, the Affordable Care Act had expanded it tremendously, basically converted the program into a much more extensive public health insurance program that covered people that were well into the middle class. Congress expected that states would resist adopting that because it's a federal state program. And so they included a provision that says, well, if you will expand this program, the federal government will give you money, will cover 90% of your additional cost. Now, there's no guarantee that that would go on forever, which is why a lot of states sort of hesitated. But there was another provision that said, and if you don't, then not only do you lose access to that, 90 cents out of every dollar coverage, you lose your existing federal subsidy for your Medicaid program. And while generally Congress can, they can't force you to do stuff as a state, but they can incentivize you by offering you money and or withdrawing money if you don't go along with their conditions. But there was a limit. In the Sibelius case, the court said, no, you can't, that's extortion. That's not conditional. That's not just placing a condition on the receipt of additional money. you basically held a gun to the state's heads. And we don't know quite what that coercion principle looks like or where the threshold is or anything, but I think those two aspects of those decisions show that, yeah, I mean, they're still, Congress can't simply do anything it wants.
I can see why President Henning would have interpreted the question that way. It's, Article 1 is dead could mean any number of things. When I heard that, I thought that what the person asking the question intended was that the power of the presidency and the courts have become so significant that Congress has very little role in the constitutional process anymore. And I think obviously it's being an exaggeration to say Article 1 is dead, but I do think that the courts and the president and the executive branch are probably proportionally more important today than the framers intended. And in many ways, I think the role of Congress has been diminished down through the years. We particularly see that with regard to the military. The Congress has very little to say anymore over, to the extent it ever did, over what the executive branch does in terms of military activities around the globe. We see that also to a large extent with domestic policies as well. The Congress, with the rise of the so-called bureaucratic state or administrative state, delegates an enormous amount of responsibility, to the executive branch to carry out the laws that it enacts. And the Supreme Court as recently as last year reaffirmed that there, under the so-called non-delegation power, Congress can delegate a great deal of authority to the executive branch. So theoretically, Congress cannot give away too much of its power to the president, but as a practical matter, it can't. There have only been two cases in American history, where both in the 1930s, where the Supreme Court ever said that Congress had delegated too much power to the president, and so more and more Congress makes enacts statutes often in a very vague way, and simply tells the executive branch to go ahead and fill in the details. That's why the Code of Federal Regulations, if you've ever dealt with it, is so extensive. When President Ford came here, former President Ford came here 25 years ago to dedicate the Beeson Law Library, he brought with him a prop of Code of Federal Regulations about that high. He said these regulations have just been enacted in the last month. And so the executive agencies have enormous power to fill in the blanks that Congress leaves for them. And to that extent, one could argue that the Congress, many people have said, abdicates this responsibility. It doesn't exercise sufficient oversight over the executive branch, and the presidency is much stronger, perhaps, than the framers envisioned. So, although Article 1 is not dead, Congress, at least in the opinion of many people, is not as active as it should be, relative to, or as powerful as it should be, relative to the other two branches of government. So.
Okay, so we've got a couple more questions from people that when they RSVP'd, but does anyone here have any questions? Okay, Adil raised his hand first.
So this question concerns judicial review. So how do we reconcile originalism with the changing societal needs, and how do we draw a balance between judicial activism and a rule-bound approach to constitutional disputes, which limits the judicial branch to just interpreting the law?
Professor Smolin, were you able to hear that? We can.
Yes, I did hear it. I'd be glad to take it. I thought I did address it the first time, but I'm glad to take that question. It seemed to be asking, how do you balance originalism with society's changing needs? Is that right?
Yes, and more so taking into account judicial activism, because your approach was, I believe, let the people decide and empower them to elect the people into Congress, and they will help balance out what exactly is it that the societal needs are. But my approach is more so from the bench than the people.
What was the last phrase? More from the bench? And I'll
just the perspective of interpreting the Constitution from the bench rather than empowering the people to vote.
Right. Right. I guess from my point of view, first of all, the major mechanism that the Constitution creates for self-governance is Republican government through representatives, and not only the Congress, but I should of course add federalism, the state level, the local level, which are meant in the original vision to be the primary entities governing us really are the states. They're supposed to deal with family law, corporate law, core crimes against the person. A lot of the areas of law that most concern us day to day are actually supposed to be governed by state democratic representative processes. So that being said, I do see a strong role for judicial review and for the courts to interpret rights and equality under the Constitution. But I see that role not primarily as one of keeping us up to date with the times, because again, I'll make the same argument. Do you want 9 people who went to law school 30 years ago, who all went to one of 3 law schools, keeping in touch with the times? Or do you want people elected last year or the year before, which is more in tune with the times? But what I do think judicial review gives us, and it doesn't have to be through activism, but the rights in the Constitution, the Equal Protection Clause, as publicly originally understood, are designed very much to say there are some areas that the legislature cannot infringe. And that's very important, that the legislature cannot infringe the rights in the Bill of Rights, freedom of faith, freedom of speech, Second Amendment right to bear arms, more controversial, the crim pro rights that govern the 4th, 5th, 6th Amendments. I think the rights that are named are very significant. They're designed to protect us against majorities. I think the notion of the Equal Protection Clause that I most embrace is that a flaw of representative government is it doesn't tend to protect minorities. It tends to encourage, minority to work with minority, sort of there are different interest groups and they're supposed to form coordinated, trade-offs with each other. But the fact of the matter is that often when democracy doesn't work, it's because we have stigmatized or misunderstood or discriminated against minorities. And that's where I think the Supreme Court and the federal courts have their strongest role. Democracy doesn't work when the majority holds prejudice, discriminatory views against groups and will not really let them fully participate. And so there is a very strong role of not for activism in the negative sense of overextending themselves, but for activism when the Supreme Court comes in and says, look, you may be in tune with the times, but the times are discriminatory. The Supreme Court is not about enacting what's popular today. It's about protecting those who are unpopular today.
Okay, Nikki had a question, right?
I'm curious about what your views are on term limits of the Supreme Court justices. If you have thoughts on whether there should be a regulatory term limits or anything like that.
Yeah, so there are a couple of interesting arguments making the rounds about term limits, and I think it wouldn't be a horrible idea. The German Constitutional Court, I think the judges on that court are limited to a single 18-year term. I think it is would probably be good for all the reasons that David mentioned, to have some regular rotation on the court. You do tend to get people now that the incentives are to nominate people when they're very young and hope that they are, blessed with rude health and will stay, on the court for 50 years. And that's probably not awesome. There are a couple of other interesting, so some of you may know that in the early days of the court, the justices had to ride circuit. They had to literally get in a stagecoach and go around to sit because there were no intermediate appellate courts at the time. They would have to sit with federal district judges and hear appeals. And of course, this created some problems because ultimately some of those appeals would end up back in the Supreme Court, and they would be sitting in perhaps on a case that they had had a hand in deciding. But there have been some arguments that maybe we ought to put the judges back on the road and send them around, riding circuit maybe during the summer when the court's not in session, as opposed to going to, Salzburg and doing, law school boondoggle gigs like many of them do. And then there's a third way that, and this again is a German example of trying to put a constitutional court separated from the rest of the political elites of the country. So the German Constitutional Court, when it was created for West Germany after World War II, was not put in Bonn, which was the capital. Berlin, of course, was in the eastern sector. It was put in a town called Karlsruhe, which is in Bavaria, and it would be like putting the it would be like locating the U.S. Supreme Court in Kansas City, Kansas. And it was intentional. The idea was we don't want the judges, we don't want this constitutional court to be so tied up with the political elites of the country, so we're just going to put it off in the sticks. And I think any of those ideas would be sort of interesting and maybe a way to, if not diversify the court, then create some separation between, the sort of power elite in Washington, D.C. and the rest of the country. Incidentally, I will mention, you might want to look for a book that is going to come out soon by a friend of mine who teaches at the University of Tennessee named Ben Barton. And Ben has done incredible research on the backgrounds of every single Supreme Court justice. And the conclusion of his book is that we have the least representative Supreme Court currently than we have ever had in our history. And I mean, so anyway, and he has some of these prescriptions, including term limits, are some things that he recommends to bring a little more diversity into the court.
Thank you, Professor Penning. So we've got time for one final question. This one's from someone online. What is your opinion on the claim that the Electoral College is an outdated system that needs to be abolished?
Can I take this one?
Yes, of course.
Okay, this is something this is another thing that I'm a little passionate about. The Electoral College is fantastic. And most of the people who are either watching this or if you're sitting in the room, you don't remember the election of 2000. We had to wait on Florida's results, et cetera. If we had a national vote, a national popular vote, if every vote was important, then we wouldn't know who our president was for months and months, because candidates would have every incentive to contest every single vote cast in every single precinct in every single state. And in a country as big as ours, I just don't think that would be workable. And I don't think it would necessarily confer any more legitimacy on the winner. I think that it was an ingenious system that they created. I think it's been refined to the point where, most horrible problems, don't manifest. And I think that that we tamper with it at our peril. And maybe Bill or David have.
Yeah, I'd like to grant it. And as a practical matter, it's very unlikely that the Electoral College is going to be abolished. There have been serious attempts to abolish the Electoral College at various times in the 19th and 20th centuries, as recently as the 1968 election, which was very close between nearly was thrown into the House of Representatives. There was extensive hearings on abolition of the Electoral College, and I always predicted that before the year 2000, that if the winner of the popular vote did not get elected president, the Electoral College would probably be abolished overnight. And, I was wrong, because it's now happened twice, and neither time was there any serious movement to abolish the Electoral College. And part of the, again, it's a practical matter, it's actually the smaller states, least populous states that benefit from the Electoral College. They're disproportionately represented, and they have a vested interest in keeping it. And since the constitutional amendment would require ratification of 3/4 of the states, somewhat more than 1/4 of the states benefit from the Electoral College in such a way that they have a built-in incentive not to vote for its abolition. Now, some of you probably know about a recent effort, the so-called compact, to do sort of an end run around the Electoral College, and don't have time to talk about that, but that is making some headway and may possibly be a way to get around the Electoral College. But in terms of outright abolition through constitutional amendment, that's just very unlikely, and probably why we've now had 2 elections in the last within 16 years, where the winner of the popular vote lost the election, and neither time was there really any serious effort to abolish the Electoral College. Although the most recent election did help the compact movement to make some headway. So stay tuned.
And we've reached our time limit. I do know that some people have to go to class at 12. So I just want to thank our panelists, Professors Ross, Denning, and Professor Smolin, for your time and joining us, and as well as the people that were tuning in online, and for everyone here, thank you. Also want to just note that the Federalist Society will be having its next event October 1st. And this will be with Greg Nunziata, who is former counsel on the Judiciary Committee to Senator Thune, Senator Rubio, and now is a partner at Minot in DC. And he will be speaking about Article 1. I just wanted to let you all know about that. And thank you so much for joining us. Thank you. Professor Smolin, yes.
Just going to thank you as well. Thank you so much.
Thank you.